Major breaking but not unexpected news out of the United States Court of Appeals for the Fifth Circuit down there in Louisiana and Texas that found that as a matter of text, illegal aliens are not part of the people, as in the right of the people to keep and bear arms shall not be infringed under the Second Amendment. This is clearly the correct ruling, and let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Terrorist Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out, and for those of you who got courtesy copies down there in Knoxville, Tennessee, that I signed and really enjoyed that experience in its entirety. Feel free to leave a review on Amazon. Always nice to hear reviews, good, bad, and ugly, about what you think of my work. All right, folks, so big news here, although not unexpected, but this is an interesting topic on X. A lot of people have gone back and forth about whether or not illegal aliens in the United States have a right to keep and bear arms, and the answer is undeniably they do not, as a matter of Second Amendment law. This is a textual issue. Keep in mind, remember, the burden, the way it works. The text of the Second Amendment has to be implicated by a law or the proposed conduct, and then if it's burdened, restricted, or whatever, or is implicated, the burden shifts to the government to show historical tradition of some sort of law that justifies the modern-day gun control law. Under federal gun control statute 18 U.S.C. 922G, those people who have illegally entered the country are not allowed to possess firearms as a matter of criminal law. And this is consistent and perfectly fine under the Second Amendment. I've explained this repeatedly on X. Some people don't like the answer, but this is clearly the right answer. And this is 1,000% going to be the answer if the United States Supreme Court ever bothers to take a case like this, which I don't think they will, because I don't think they're going to have to ever deal with such a kind of argument. So the bottom line is, textually, we know what the Second Amendment says. The operative phrase, the right of the people to keep and bear arms shall not be infringed. The question is, who are the people? Well, we know who the people are because the Supreme Court has told us this based on history and long-standing Supreme Court precedent. The people are all those people in the United States, those individuals in the United States who are part of our national community. People that break into the country illegally, people that stay in the country illegally, people that arguably are working jobs fraudulently using fake IDs are obviously not part of the people because they're not part of our national community. They're not part of our political community. So as a matter of text, the right of the people to keep and bear arms shall not be infringed does not apply to illegal aliens. This is both common sense and just matter of precedent. And a lot of people on X have complained about my position, but this is clearly the right answer for a whole host of reasons. And there's no doubt in my mind that all the serious judges in America, including the U.S. Supreme Court, is going to find exactly what I just said to be the case, because they're going to find at the textual level, illegal aliens are not part of the people. And that is exactly what the Fifth Circuit said in this decision in the case of United States versus Jose Mandino Cantu. Mandino Cantu, I hope I pronounced that correctly. They said in this case he was found to have possessed a firearm illegally. He argued under the Second Amendment he was entitled to have this firearm, and the Fifth Circuit says no can do, not only because it was consistent with prior Fifth Circuit precedent, but it's also consistent with the Supreme Court decisions of Heller and Bruen talking about the definition of the people. Now, specifically, this is what the Fifth Circuit said in rejecting the argument that illegal aliens have the right to keep and bear arms under our Second Amendment. We agree with the government and hold that the Supreme Court's decisions in Bruen and Rahimi did not unequivocally abrogate Portillo-Muñoz precedent. That's a particular precedent from the Fifth Circuit that said illegal aliens did not have Second Amendment rights. And as such, the Fifth Circuit continued, under this circuit's rule of orderliness, we are bound to follow Portillo-Muñoz, the decision. Thus, the district court's judgment against Mr. Mandino Cantu is affirmed. So again, the rule of orderliness is worth noting here. The way it works is if the precedent in the circuit has previously resolved an issue and there's a subsequent Supreme Court case, then that Supreme Court case obviously wins the day. But if the Supreme Court case does not clearly abrogate or eliminate the prior ruling by the Court of Appeals, that prior ruling by the Court of Appeals stands. Here, there was an earlier decision by the Fifth Circuit many years ago that said illegal aliens were not part of the people, as in the right of the people to keep and bear arms. So Mr. Mendino Cantu's argument here was that the decisions of Bruen and Rahimi changed the definition of people in such a way to cover illegal aliens. The Fifth Circuit says that is clearly not true, and therefore you lose this appeal. Now, I also want to note a concurrence by Judge James Ho. Now, there are certain judges out there that I've been flagging as potential Supreme Court nominees by a new President Trump. One is James Ho. Now, you may recall Judge James Ho because he is the author and he wrote some very powerful concurring opinions that supported the Rahimi decision that said that 18 U.S.C. 922 G8, which Mr. Rahimi was convicted under, was unconstitutional on its face. The only Supreme Court justice that agreed with James Ho's analysis was Justice Clarence Thomas. Rightly or wrongly, I'm not going to get into that debate. It doesn't make sense. But I do know that we weren't going to get 5 votes to say that that law was unconstitutional on a facial matter, even though Judge James Ho did so, and not irrationally so, by the way. But nevertheless, it did not prevail with the U.S. Supreme Court. But Judge James Ho is back. He, again, is referring here that illegal aliens simply do not have the right to keep and bear arms, which textually is clearly the right answer. This is what Judge Ho says. Remember, Judge Ho is the Rahimi author. Here's what he says about illegal aliens and the Second Amendment. It's already well established that illegal aliens do not have Second Amendment rights. In United States versus Verdugo Urquejes, the court noted that the people is a term of art employed in select parts of the Constitution, namely the First, Second, Fourth, Ninth, and 10th Amendments. The term refers to a class of persons who are part of a national community or who have otherwise developed sufficient connection with this country to be considered part of that community. Now, I want to mention that this case that they talk about, the Verdugo case, deals with the Fourth Amendment, which is the right to be free from unreasonable searches and seizures. But now Judge James Ho talks about whether or not that's an important distinction in this context, using a Fourth Amendment case to apply to the interpretation of the Second Amendment. Here's what Judge Ho writes. To be sure, Verdugo involved the interpretation of the Fourth Amendment, not the Second. But the court later quoted the same passage verbatim when it was determining the proper reading of the Second Amendment in the District of Columbia versus Heller case. And the last point that I think is worth mentioning about this, that Judge James Ho just points out it's just absurd to think that illegal aliens would have Second Amendment rights to keep and bear arms in this country. Here's what James Ho, the judge in the Fifth Circuit, concludes in his concurring opinion. Illegal aliens don't qualify under the definition of the people set forth in Verdugo and in Heller, not as a matter of common sense or court precedent. As to common sense, an illegal alien does not become part of the national community by unlawfully entering it any more than a thief becomes an owner of property by stealing it. And as to precedent, the court has repeatedly explained, that's the Supreme Court has repeatedly explained, that an alien does not become part of the people or one of the people to whom these things are secured by our Constitution by virtue of an attempt to enter forbidden by law. So there you have it, folks. So let me cut to the chase. If you're ever confronted with someone that says that illegal aliens have Second Amendment rights, you must immediately tell them that is BS, not true. It's no good for the Second Amendment community. There is no benefit to the Second Amendment community to argue this. It's terrible all the way around. It's simply not true. And again, don't make this argument because it's going to hurt your credibility with all the federal judges and the Supreme Court that are going to view that kind of argument as hooey. The only people that really are going to try to argue that illegal aliens are part of the Second Amendment, i.e. the people, are people that have an obligation to do so, i.e. criminal defense lawyers. They have to do their job, and you can't hold that against them. But more importantly, the only other people are those that are going to try to discredit the Second Amendment by saying, look how absurd it is. We have an amendment to the Constitution that lets illegal aliens have the right to keep and bear arms and shoot people with guns, etc., etc. You know where this is going to go. None of that's true, and we don't want to play into that sort of anti-gun argument. So if you see lower courts saying that illegal aliens have Second Amendment rights. Inevitably, my guess is those will be anti-gun judges trying to thumb their nose at the United States Supreme Court and our Constitution, including, but not limited to, our Second Amendment. All right, folks, there you have it. I hope you learned something here today. Make sure you follow me on X. I have over 17,000 followers. Don't forget to subscribe to this channel and like this video, and we will see you again very, very soon, I hope, here at the Four Boxes Diner.
Orders up. Table 2A.